here with us today for our webinar on how to become an advocate on record at Supreme Court, organized by BSK Legal. BSK Legal is one of India's leading law firms, having its office at New Delhi. The firm has an all-India presence through its alliance with local councils at different locations for all states and union territories of India. BSK Legal, under the able guidance of Sanjay K. Chadha sir, has successfully conducted numerous webinars with prominent personalities on various important topics of law and has furthered its motto of spreading legal awareness far and wide. As all of us as students and budding torchbearers of law and justice are grateful to be a part of spreading legal awareness campaign, where we get the opportunity to broaden our horizons of legal knowledge.
Thank you, Ananya. A very pleasant afternoon to all the dignitaries and my friends. A motivating, inspiring, and hardworking person, the person behind the happening of this session, the person with the most enigmatic personality and the humble guide that every law student longs for in his or her legal journey. With no further ado, please join me in welcoming the founder of BSK Legal, Advocate Sri Sanjay K. Chadha. Sir, please enlighten us with your kind words.
I'm so thankful to you, Devamoy. And first of all, I really, from core of my heart, would like to thank the respected Neela ji, Shri D.K. Sinha ji. Both of them are very prominent faces every day. You see them in Supreme Court, and they are doing lot of work in Supreme Court. Both of them are always there in Supreme Court, like me, not like me, who is there in other courts also. They are permanently there and doing wonderful work and serving the people in their own way. Advocate Neela ji is not a advocate on record, but because of her presence in Supreme Court, it is very important for all of us to know what it takes, all of us, to reach there. So as today we have a lot of people who are from law background, legal, doing law, and they have ambition to practice in Supreme Court. So we will be seeking your guidance, and it is my pleasure to welcome you now. And at the same time, my dear friend, very, always on, whenever you call him, DKG will always help us in Supreme Court. I've seen it in last so many years. And he is also very active. I have seen the number of cases filed by him. If you just go and file, is I think the second largest number of cases are with him. So a very well-known face in Supreme Court. DK Bhai, we really welcome you here. And because today's subject is on Supreme Court, so I couldn't get anybody better than both of you. And I requested you too. And I'm very thankful to you that on my request, both of you have agreed immediately. So I would request the teammates, Arpita, Ananya, Devamoy, and we have got Big Vijay. He's always there to support us. He's our backbone in terms that he does all the work, how this streamlining is to be done, and so on and so forth. So thank you very much. The entire team, thank you very much. Ananya, please take it forward. And we all are waiting to hear both of our esteemed speakers.
Thank you, sir. You have always been a great guidance for all of us. Now, without further ado, I would like to welcome and introduce our first speaker for the event, Mr. Dharmendra Kumar Sinha, sir, Advocate on Record, Supreme Court of India. Sir has a valuable experience of 20 years as an advocate on record. He became advocate on record in his first attempt in the year 2002. He is an expert in the field of industrial disputes and criminal law. However, his practice pervades in all fields of law.
Sir has been contributing to India's legal field since past 2 decades, and he also has settled the meaning of life imprisonment in the case of Ramraj alias Nanu versus State of Chhattisgarh, reported in 2010-1 SCC 573. Sir has the privilege of becoming an AOR, advocate on record, and conduct cases on behalf of several dignitaries in their private capacity, including that of chief ministers of various states and cabinet ministers of union as well. Apart from his expertise, Sir has also been an arbitrator at a very young age. Today, we at BSK Legal take great pride in welcoming Sir to impart his knowledge and guide numerous students about how to become an advocate on record. Thank you for accepting our invitation, Sir. Over to you.
Please. Good evening, my colleague friends, law students who have joined in, ladies and gentlemen. First of all, I am really overwhelmed by the introduction given by my own colleague, Mr. Sanjay K. Chadha. And here I find that Sanjay and Neela both are themselves an excellent practitioners in the Supreme Court. About 8 days back, when I was discussing a case with Sanjay, I also happened to be his advocate on record. It was relating to a case, namely 4A Securities. Then suddenly out of the blue, he asked me whether I would like to guide some juniors in his office who are taking the exams of advocate on record this time. I replied in affirmative. Thereafter, on the very next day, he came up with this proposal. Initially, I was very hesitant because I had already passed in the year 2002, and today we are in 2022. So I have to recollect my memory about 20 years back, and therefore what is said is that there is no outlook or roadmap by which the youngsters could prepare for this examination. So I realized it was the same case with me also. I did not have any guide at that time. I had to devise my own methods. So I agreed for this session. Now, coming to the topic itself, I would like to divide this topic into two parts. First, for those who are giving the exams this very year, and second, for the law students who will be giving the exams in the future. As you know, there are 4 papers. Each paper carries 100 marks. You have to pass the twin test. That is, the first test is you have to get 60% in aggregate, and the second one is 50% in average in each paper. If you are a regular practitioner in the Supreme Court, then you hardly get time. So I can only say what I did, because everybody has his own methods of giving this examination. Everybody has his own techniques. I can only fondly remember what I did 21 years ago. And if there is any update, you need to update yourself, because I have been lost in touch for such a long time. And as far as I was concerned, I just got 12 days time to prepare for this examination. On the very first day, I went to the library and got the head notes of leading cases and the syllabus. The next day, someone told me that you need to get question papers also. So on the next day, I went for the question papers, which was available in the library. Nowadays, these materials are very much available with the shop vendors also, who are in the vicinity of Supreme Court. Then when I was having that question papers, I met one female advocate with whom I got in touch, and we were partners so far as the discussion of leading cases are concerned. First of all, I would like to start with leading cases because this consumes the maximum time of your preparation. It is always advisable to have a partner so far as the leading cases are concerned, because of the reason that you have hardly 5 years of practice and you are dealing with judges who have pronounced the judgment, and the minimum judgment which have been pronounced is by the 5 judges, and they are the best brainies in the entire country. So doubts do arise at this young age, and if you have a partner or a colleague or maybe 2 or 3, you can discuss out in your canteen, on telephone, etc. And this clears a lot of doubts. In my case, what I did was I asked her to give me an example that you prepare on topic A, and I used to prepare on topic B. Then we used to discuss on telephone because I was running very short of time. But I made it a point that once I have heard the topic A which she delivered, within 24 hours, I must read that, because that time the memories are fresh and you get an in-depth knowledge. Now, after getting these all head notes, I sorted out these head notes topic wise. For example, 368, Amendment to the Constitution of India. The very first one was Minerva Mills, then below that Keshav Nanda Bharti, Shankari Prasad, etc. So the latest judgment was read by me at the very first instance, because that contained previous year's judgments also. Since the time was running out, so I adopted the strategy of selective and intensive study. So far as leading cases are concerned, I selected 13 topics and made an intensive study of those topics. But at the same time, I was aware that in case if I miss 1 or 2 questions, then what will I do? So therefore, 2-3 topics I kept for a standby, and I read only the conclusion part, that is what the law is, so that you have a faint idea in the examination hall regarding those 3-4 topics. So I gave a number to the sorted out notes. Now, so far as the numbering system is concerned, I fondly remember what we have been told by our parents regarding our beloved President, Dr. Rajendra Prasad. There were a lot of stories which had been told to us by our parents regarding him. One of them was that in the question, in a subject, it was asked, write any 5 answers out of 7 questions. He wrote all of the 7, and on the top, he had written, check any file. Another incident of his was, what we have been told by our guardians is that the invigilator who was checking his copy, he said that the person who is giving the examination is better than the invigilator. And to quote the words, it was written, the examinee is better than the examiner. And that book, that copy, you also find in the museum. Then a news reporter went to him, Dr. Rajendra, sir, how is it that you remember everything, whatever you have read, the files you have read? So he answered in only one sentence. I just gave a number to each file which I read. So for a wise man who could read between the lines, it was a reflection of using the system of number. That is, you number 1, 2, 3, etc. Now coming to the topic back, I numbered this, made an index, and then proceeded. Now the second step which you have to do is that you have to make a research of annual digest on these topics. This is available in Supreme Court Annual Digest for the last 2 years. And what has to be seen in those is, first, the name of the judges, honorable judges of the Supreme Court who have reiterated the view. Number 2, the name of the case. And number 3, the citation. And number 4, the date of judgment, if possible. Now, to conclude this part, since I was running out of time, I adopted my own method, that is selective intensive. And if you have got time, please go through the entire head notes extensively. But what the method I used was quite different. I first of all read the facts of each case. Then the second step was the conclusion part, so that I must know what the law is as of today. And the third one was the principles on which this particular judgment was based. And the fourth, the turning point, the major judgments which have been overruled. And the fifth one was whether I could have a different reasoning to that of the Constitution bench, or if I agreed, if I could dissent from that Constitution bench judgment. So to summarize this topic of leading cases, first of all, you must know what the law is as of today. That is number one. Number two, the principles on which this law is based on. Number three, how the law has evolved. What is the roadmap? What are the turning points and the significant judgments which have been either reiterated or overruled? And number four, whether you can have a different point of view to that of the Constitution bench. This has to be supplemented with the latest judgments, the name of the honorable judges, then the name of the case, citation, date of judgment, etc. There's one more question which is asked normally in the advocate on record examination is the judgment by 7 or more judges bench. There are some peculiar remarks which are given therein, and it is being asked that in which context it has been given. So you need to know, get through those peculiar remarks and see in which context it was given. Now there's a lot of change in the syllabus since last 20 years. It has been revised. So kindly update yourself on that. Then one more important facet of this examination is that you will get head notes of leading cases in the examination hall. What is the purpose of giving these head notes? In my view, the purpose of giving these head notes is only a touch and go. In case if you are not able to recollect some conclusion or some judgment which has been overruled, you just need to go to that particular paragraph, note down and shut the book down. If you are in any kind of a confusion that you will be able to write by these head notes, there is a reasonable possibility that you may miss 1 or 2 questions. So this is as far as leading cases are concerned. It is always advisable to have 1 or 2 partners, associates, so that you can discuss and clear your doubts. Now coming to the next paper, that is paper number 1, practice and procedure. In this, I sorted out the short questions and the long questions. Now for both these type of questions, Baer Act was the foundation stone. So far as short questions are concerned, the Baer Act is more than sufficient. For example, in our times, we had to write what are the powers of a chamber judge. Now, if you see the powers, there are n number of powers which have been given. So you have to devise your own method how to shorten it. For example, I wrote the Honorable Judge in Chambers can decide the following applications. 1, substitution, then continuation of delay, etc. So far as the long questions are concerned, you need to supplement with the books which are available. I will not like to advise you, since I am not update on that. 20 years have already gone by. So kindly update yourself regarding the books on this topic. There is another facet to this practice and procedure. The facet is that you need to research for the last 2 years on these topics. Again, the name of the honorable judges, because it gives a reflection to the examiner that you are actually practicing in the Supreme Court. And then the name of the case, the citation, the judgment, and what is the view which has been taken by him. then in the examination hall, you have to be absolutely open-minded. Take no prejudices against that you have. Do not confine yourself to this particular subject. There can be other subjects which may be of help. So far as, please, wherever it is relevant, write them. That gives you an extra edge. So far as leading cases are concerned, so far as practice and procedure are concerned, rather in every paper, you should be absolutely open-minded. Then coming to the next paper, I think it is drafting, paper number 2. I got a syllabus. Some changes have been made. I asked my clerk to get it. This drafting is drafting for petitions for a special leave petition, the suit under Article 131, the review petitions, transfer petitions, decree, and some applications. So, if you have a grasp on the special leave petition, which is hardest of them, then the others are very easy, and rest is the format. So far as the special leave petition is concerned, it can be broadly classified into 3 categories. The first one would be the list of dates. The second is the question of law. And the third would be the grounds. I started with the grounds because that is easy. You get the question papers of the last 5 to 10 years. They have given circumstances mentioned therein, and then you have to write this SLP or transfer petition, etc. Now, after making the grounds, you need to improve upon these grounds. Broadly, I can say what has to be stated in the grounds are: you have to state the broad propositions of law, number 1, which is sought to be violated. Number 2, the specific statutory provision which has been infracted. Number 3, you have to hit the point which is involved therein. And number 4, if there was a recent judgment on that particular point, you should, which is relevant, you have to mention it. So far as the grounds and question of law is concerned, you will have to write just 2 to 4 questions of law. And so far as the grounds are concerned, 4 to 6 would suffice. Now, this paper contains 2 biggest challenges. The first challenge is the time management, and the second is the formulation of question of law. Initially, you find it difficult to formulate question of law, but you have to keep on improving the quality of your question of law. You have to keep on improving and improving. Mind you, if your quality of question of law is par excellence, then the examiner is more than willing to give you his discretionary marks wherever possible, because he will be impressed by your question of law. Then we have synopsis and list of dates. So far as I was concerned, I was running short of time, so I just wrote synopsis of 1 in 1 answer. So even if you don't write synopsis, that does not make much difference. But if you write synopsis, it has to be in 1 paragraph. That 1 paragraph should be where the law has been violated. And nothing more, because you are running short of time. Then coming to the list of dates, you have to highlight the positive points of your case in 1 or 2 sentences. At the same time, the negative points have to be shrunk, but it is impermissible not to quote the negative points so far as SLP is concerned. Now, in this leading cases, in the last 2 or 3 days, you have to actually practice in writing the certificate part and the affidavit part, because if you don't practice, then your mind will be blown apart in the examination hall. So if you practice at least for 2-3 times the certificate, the affidavit by writing, just like you do in maths, it becomes quite easier in the examination hall. So the point is, you've got to focus on the question of law and have a time management. You have transfer petitions also. I'm saying we have transfer petitions. So far as transfer petitions are concerned, the grounds are like, these transfer petitions are based on the inconvenience of the parties, the hardships caused to the parties. So the grounds could be the distance is so long. For example, I'll give an example. Let us say a wife seeks a transfer from Nagpur to Kanpur of a divorce case. So you could say the distance between Nagpur to Kanpur is 850 kilometers, and it will require 14 hours of journey. Secondly, grounds could be she has a small child and it will be very difficult for her to travel. Thirdly, there could be a threat to life. Fourthly, there are already cases pending in the Kanpur. Likewise, so and so, depending upon each fact of the case. Then we have other topics also, like review. Review is based on primarily 3 grounds. The first one is there is a typing error. The second is an error apparent on the face of the record. And the third is the subsequent events. Likewise, we have contempt. The civil contempt is normally a violation of an order. So it is very easy so far as the rest is concerned. Now, coming to the last subject, that is advocacy and professional ethics. In our times, we had to give accounts and professional ethics. Each was divided into 50 marks. So I cannot give much guidance, because many of the advocates used to fail in the accounts. So probably they have a lot of complaints being received, and that is why they have done away with, in my view. In any case, some kind of outline I would like to give, that this topic contains, you have to go through the Bayer Acts of Advocates Act, the Bar Council of India rules, and the Supreme Court rules, the Contempt of Courts Act. For me, frankly speaking, it was like sailing in the ship in the sea with no shore coming. So you keep on writing. Frankly, if you ask me to speak today on what are the duties of an advocate, I can assure you I can go on for 2-3 hours. But therefore, you can keep on writing. It is an endless so far as the advocacy and professional ethics are concerned. So what should be the approach? Because that would lead you to nowhere. So I adopted an approach of comprehensive method, the totality approach. I divided the topics into heads and again divided them into subheads. Before going into the examination, I just went through these heads and subheads. And once I read extensively everything in the book, and at the last moment, only these subheads and heads were required to be seen. For example, you have what are the duties of an advocate? Now, I divided into the duties of an advocate inside the court. Number 2, towards his profession. Number 3, the duties of an advocate towards the society. Then you keep on subdividing it. The next aspect would be, so far as this case is concerned, that you have to go through the celebrated judgments on the Advocates Act, the Contempt of Court Act, and you have to be very thorough. You must know what the law is as of today. Then the third aspect of this is that you should have a research of the last 4-5 years. In earlier papers, you had a research of only 2 years. But so far as this topic is concerned, you need to have a research of 4-5 years because this is a very short one. And check the judgments on these points. Then there are books which are available in which there is also one question which is asked that of a peculiar remarks, the context in which these peculiar remarks are being given. And the last aspect of the matter is that there are or there may be some news which have been in headlines for a considerable period of time. If there is any headlines for a considerable period of time in the recent years, please go through that judgment entirely, because it is likely that it might be asked. Then this is as far as all the papers are concerned. Then we have a lecture series which is immediately prior to that of the examination. In this lecture, you might get a hint of the questions which are involved. So far as I was concerned, I could attend only one lecture because I was running very short of time. That of Mr. Harish Salve. His concepts were amazing. And one element of precaution, which I must say, that there have been instances where nothing has been asked from these lectures. So you must be prepared for the surprises. Then you should go to the examination hall completely open-minded. You use your experience which you have in the courtrooms outside in the practical life, wherever anything is relevant, that may be of some input in your exams. Now coming to the last leg, one of the favorite questions which normally every aspirant asked me who had approached me is that how much time it takes for the preparation. Well, for a regular practitioner in the Supreme Court, you have already covered 2.5 subjects. The practice and procedure is there. You know this. The drafting is already in all the offices of the councils, and to some extent, the advocacy and professional ethics, you know. So the only focus for a regular practitioner should be that of leading cases, which is really given by 5 honorable judges and more, and which requires discussion, which requires clearance of doubts, which requires that you must know what the law is prevalent as of today. Then, so far as I was concerned, I used to study from, so answering the question, so far as the regular practitioners are concerned, 15 to 20 days, in my view, is sufficient. So far as those who are occasional, I think 3 to 4 months is definitely required for them. So far as I was concerned, I used to study from late night 9 to 5 in the late night hours, because I was a bachelor at that time, living with my bachelor friend, Mr. Sikandar Arora, who is now practicing in Canada. So he was in a different state in the evening, and it was very tempting for me, but somehow I got hold some days till the exam is over. Then either you can study in the very early morning or in the late night.
We have many questions, Mr. Sinha. So I think you have given us a, we want to know about when this exam takes place, what is the procedure, whether it is compulsory that the person should be practicing there, and series of questions are there for which we will come back to you after your lecture. So you
that is in the second lecture. That is the second part which I have given. It is for the law students.
Yes.
This first part I am giving for your office juniors.
All right. Thank you. Thank you very much.
So either you can study early in the morning or in the late night hours, because that gives a kind of flow to your study, and the deepest level of concentration would be when you are in state of flow. For example, if you have seen a small kid who is saying his favorite serial, like say Doraemon or Motu Patlu, whatever, so he will not go away till that is finished, despite the fact that his mother would be yelling at him or his parents would be shouting at him. He will stick his entire focus on that. So an element of precaution has to be there for those who are studying in the night, that please switch off your net facilities, because you may also read some different subjects on WhatsApp University, and if the subject is interesting, that can go for hours together. At that time, we did not have WhatsApp. So it is better if you have a flow in your system, and there has to be a tendency to finish. Please develop a habit to finish things. Make it a point to finish the many targets you have. If you're not able to finish, let us say 3 leading cases in next 6 hours, then you reduce at the very next session, make it 2 cases. If you are still not able to, you further reduce the many targets. As you see in the apex court itself, even the honorable judges, even though they have been assigned 68 to 75 matters on an admission days, they are able to finish those targets. It's a mammoth and Herculean task. But once you have developed the habit of finishing things, then it takes you leaps and bounds. So to summarize the first part, that is, you must have a flow. Number 1. Number 2, you must have a habit to finish. And number 3, the numbering system. Again, to repeat, first, flow. Second, you should be able to finish tasks. And third, you must use the technique of a numbering system. There's also a third point of view. That is an old proverb in English, make hay while the sun shines. But if you are able to keep the distractions away, then your sun will definitely shine. Otherwise, you will be seeing the stars in the examination hall. With this, I conclude the first part. So far as those who are giving exams. Now coming to the second part for the law students. For the law students, as you know, that for initiating this particular examination process, you need to have 4-year experience at the state bar rolls. Thereafter, you have to choose a guide. That guide must be an advocate on record, having 10 years of experience as an advocate on record. The third step would be to undergo that compulsory training under him for 1 year. For that purpose, you have to be at Delhi and undergo training under him. There are certain certificates which you are required to, that you can see from the rules, Supreme Court rules itself, which I need not elaborate. And after going the 1 year compulsory training, then you are eligible to give this examination. Now, this examination of advocate on record is conducted either once or twice in a year. Normally, it is in summer vacation or winter vacation, that is in June or say December. And 1 month prior to that, you have to give a writing that I want to take this year examination. Now they have restricted it to 5 attempts. You cannot give more than 5 attempts. Then coming on to the system of advocate on record, being a law student, you also need to know where does this system of advocate on record comes from. Well, under Article 145 of the Constitution of India, the Supreme Court has been vested the constitutional power to frame its own rules, which is also supplemented by Section 52 of the Advocates Act, which says that notwithstanding anything contained in this Advocates Act, let me read it. Nothing in this act shall be deemed to affect the power of the Supreme Court to make rules under Article 145 of the Constitution for, I will read the B part, for determining the persons who shall be entitled to act and plead in that court. Then I would just like to quote only two, though there are many. There's a complete section on advocate on record under Order 4, but two provisions I need to mention. The first one is Order 4, Rule 1B. Now this says that no advocate other than an advocate on record for a party shall appear, plead, and address the court in a matter unless he is instructed by the advocate on record or permitted by the court. So the words used here is shall appear, plead, and address the court unless he is instructed by the advocate on record. Permission by the court is normally in cases of appointment of amicus curiae or in cases of party in person. The next provision is Order 4, Rule 7. An advocate on record on his filing memorandum of appearance on behalf of a party accompanied by a wakalatnama duly executed by the party be entitled to act as well as to plead for the party and to conduct and to prosecute the civil proceedings, etc. Then the C reads that no advocate other than an advocate on record shall be entitled to file an appearance or act for a party in the court. So therefore, you need to have instructions for filing this, any petition. You need to have, filing can be only done by an advocate on record. Every advocate on record needs to compulsorily have an office within the 16-kilometer radius, a registered clerk, etc. Now, one of the questions which a layman might ask is why the system of advocate on record? Well, I'll give you just a small example. Supposing an advocate, let us presume that this system was not there. Then an advocate from Tamil Nadu would file a case and get a stay order. And when the respondent appeared, if he was a counsel from Assam, and say respondent number 2 might be from Jammu and Kashmir Council, or third counsel could be from Gujarat, Maharashtra, etc. So he has to serve these copies on them before filing an application for vacation of stay. So it is almost an unworkable system. Therefore, they have devised this system of advocate on record, which serves multiple purposes, including it not only smoothens the court process, it helps the registry. At the drop of the hat, you can get the matters listed. Urgent matters can be listed at a very early time. Then, why should a person become an advocate on record? That is also a facet. Well, once you become an advocate on record, I personally have felt that your respect within the community as well as outside the community, outside the profession, is enhanced by leaps and bounds. Everywhere you are welcome, everywhere you are treated with respect. I go to my village, there I am treated with a lot of respect because of this becoming an advocate on record. And secondly, you also get a remuneration, and this takes care of your gestation period. Everybody has his own charges for filing a petition as an advocate on record. The standard charge by an advocate on record is somewhere around, say, rupees 5,000 to 25,000 per case. Then there have been various advocate on records who have went on to become senior advocates and the honorable judges of the Supreme Court. A large number of advocate on records have become the honorable judges of the Supreme Court. I'll give you only a few examples. Today, in the Apex Court, we have Honorable Justice Uday U. Lalit, who will become the next Chief Justice of India. He had a roaring practice as an advocate on record. Then the first woman advocate to be directly elevated in the Honorable Supreme Court was Honorable Justice U. Lalit. Then even today, the senior most, the third judge, Honorable Justice A.M. Khanvilkar, he had a roaring practice. I know him because my chamber was number 8 and his was 12, and he was having a roaring practice. All the three advocate on record had a roaring practice in Supreme Court. They were known for their integrity. Justice Lalit, Justice Indu Malhotra, Justice Khanvilkar, they were known for their integrity in the profession. And lastly, to conclude, the importance of an advocate on record can't be highlighted better than in today's world. We have His Excellency, the President of India, Shri Ram Nath Kovind, who was an advocate on record before becoming the President of India. With this, I conclude and hand over to Sanjay.
It was so enlightening, and everything is given to us in a platter. Thank you very much. So kind of you. And I would like Arpita. And we'll come back to you, sir. D.K. Sinhaji, please wait. We might have some questions from you. First, all of us are really waiting for to hear Neelaji. Arpita, please.
It is a moment of extreme pleasure to welcome the guests who are present here to attend this conference. On behalf of BSK Legal, I, Arpita, am delighted to take an opportunity to introduce our second chief guest, Neela Gokhale, who is an alumni of Indian Law Society's Law College of Pune. Having completed her LLB in the year 1992, she went on to complete her LLM from the University of Pune and thereafter a doctorate in law from the Bundelkhand University, Jhansi, Uttar Pradesh. Her topic for research was Towards a Common Law of Adoption. Having worked for many years in the field of domestic and international adoption and having rendered pro bono services to institutions housing destitute women and children such as Kusumbai Moti Chand Mahila Seva Gram, Pune, among others. She has practiced law at the district level in the Pune district courts, including family courts and others. Thereafter, continued her practice in Supreme Court of India, New Delhi, since the year 2007. She has also advised promoters, builders, and developers in completing housing schemes, right from purchase of land, executing development agreements, flat booking agreements, examining the title of registration of societies, and among other things pertaining to drafting and conveyancing. As far as litigation is concerned, she has been actively involved in appearing in matters of civil, criminal, and constitutional nature with the Honorable Supreme Court of India, High Court of Delhi, and Bombay. She has also filed PILs in her own name as well as on behalf of persons interested in doing so, which include seeking efficacious mechanism for voting right for armed forces personnel, challenging various gender-biased provisions, proceedings seeking codification of immunities and privileges for parliamentarians, etc. Now, I would like to hand over the mic to Ms. Neela to further take the discussion ahead. Thank you, ma'am. Over to you.
We are really grateful to you, ma'am.
Thank you. Thank you.
Thank you very much. And you've been very patiently part of this. I'm so grateful.
Thank you so much. I'm very happy to be here and very gladly ready to address your students and all the budding lawyers over here. But first, I must appreciate and actually congratulate Mr. Sinha on the commendable and the most comprehensive discourse on what actually is an advocate on record and how much effort we need to actually put in to successfully complete the examination. And I'm so, I was really, while listening to him, that's probably the reason why I'm not an advocate on record, but I would have never managed what he has done. So in, successfully completing the examination. It looks very tough, but he made it very simple and very easy to, sounds very easy to actually conquer that thing. I think Mr. Sanjay Chadha has invited me here. The topic is advocate on record and how to become an advocate on record and the importance of an advocate on record. So he knows very well that I am not an advocate on record. But I think the perspective with which he invited me to actually speak a few words to you is probably to give you a perspective from the other side. So there is one side which says that yes, you need to be an advocate on record to practice in the Supreme Court of India, as in to file wakalats in the Supreme Court of India. But does that really bar or put you oust you from actually practicing in the Supreme Court of India? So I think he's got a very good perspective from Mr. Sinha, who himself, being an advocate on record, has really, he has been practicing for so long, and he's given you so many insights in the said practice. Now, for me, if just to say a few words, because I know all of you must have been very enthralled by the comprehensive lecture just prior to me. So I won't actually take much of your time. But what I do want to tell you is that advocate on record concept is there only in the Supreme Court of India. So as lawyers, as budding lawyers, if you don't want to give this exam, if you don't want to become an advocate on record, there are opportunities available to you, as the opportunities which I seized, because when I came to the Supreme Court, it was too late in the day for me in practice. I came after, say, 12 years of practice under my belt. Before the Supreme Court, I was a trial court lawyer. So for me to come here and again, work with an AOR, get a certification, and then give the exam and then start filing would have been a real delay for me in getting right into the mainstream of practice. So there are other opportunities for you who do not want to be advocates on record, although that is obviously a bonus and an additional qualification which will always keep you in good stead. Now, something which probably Mr. Sinha would have been answering you in the question answer section. So I'll just give you a brief capsule on the role and duties of AORs and what it is actually to be an AOR from the perspective of a person who is not an AOR. Now, Article 141, where do you get the concept of advocate on record? Like he said, the Advocates Act itself provides that Supreme Court is entitled, vested with the jurisdiction to make these rules, apart from for senior counsels or for advocate on records and any other mode. So the Constitution of India under Article 141(1) itself has given the Supreme Court the power to make rules for regulating generally the practice and procedure of the court, which includes the persons practicing in the courts. And therefore, this act, that is the Supreme Court rules of 2000, initially 1966, but thereafter amended, and the ones in existence are 2013, the Supreme Court rules, practice and procedure rules, and chapter 4 of those rules actually deal with the subject and the topic of advocate on records. Now, advocate on records are those through whom and whom alone you can file anything in the Supreme Court. Obviously, you can file a petition in person, for which you don't need any advocate, or either a one on record or one without on record. You can file a petition on your own as a petitioner in person. That's point number one. Now, if I want to practice in Supreme Court, I have to have an association with an advocate on record who will file matters for me. The entire object is actually to pinpoint accountability, pinpoint responsibility, and the address for service and who is going to be actually taking the responsibility of ensuring that the translations are correct, the contents of your SLP or your writ petitions are correct and responsibly made. It is these advocate on records who are actually doing a very responsible job of much responsibility, because it is ultimately, even if I have drafted a petition, a client comes to me, I draft a petition, but I need obviously an advocate on record to file it. Then I go to Mr. Sinha and say, Mr. Sinha, please, would you go through this petition and file it? He actually has to have trust in me, the petition which I have made, the instructions which I have taken my client, and then only on the basis of that trust, he will agree to sign my petition, sign the wakalatnama, which actually the client would give to him and not to me, and then file it. So if at all something happens in the petition, there are some incorrect statements, or some process is not issued, or some steps have not been taken, ultimately it is not me who's responsible, but it will be Mr. Sinha who will be held accountable. And for that purpose, that is why I said the responsibility of filing and conducting matters in the Supreme Court will principally be burdened and be shouldered by an advocate on record. So you have to be a persons of integrity and persons of immense responsibility to actually discharge this function. I can just wash away. Of course, he would definitely catch hold of me if I've made some wrong statement and make some complaint against me. But principally, the Supreme Court will hold him responsible. So he has to be the one who has to be very alert and vigilant as to what he is filing. Now, coming to the duties and the role of an AOR. Okay. Now, like I said, only an AOR can file the wakalatnama in the Supreme Court on behalf of a client. The wakalatnama, it is a document engaging a lawyer to appear and plead for you in any court of law. A wakalatnama is something which has to be given by the client to a lawyer, irrespective whether he's an AOR. Especially only in the Supreme Court, he has to sign it in the name of the AOR. But in all other courts, the lawyer who is going to conduct the matter is supposed to be the person to whom the wakalatnama is given. Then, like I said, no advocate other than AOR can appear and file a matter in the Supreme Court, and it is the AOR who always has to be present while the matter is being argued. He is the person who is instructing the counsel, advocate who is appearing, or a senior counsel who has been instructed to appear in the matter. Then any notice which is going to be sent by the Supreme Court registry in any petition, writ petition, SLP, or any other petition will be to the office of the AOR. All that correspondence will be to the AOR. Then it is necessary to get a certificate issued by an AOR in order to file a SLP under Article 136. And an AOR is personally responsible for the due payment of the fees payable to the court. Now, like these are the actually very important duties of an AOR. Now, what are the qualifications to become an AOR? As Mr. Sinha said, I will not take your time in repeating them, but just go through them quickly. He must be enrolled with any state bar council. He should not be designated as a senior counsel. As in, the designation, if at all a lawyer is designated as a senior advocate from any of the high courts or the Supreme Court, he will cease to be an AOR. So from that moment onwards, a senior designated counsel will not be able to file any matter in his own name as an AOR. So he has to inform the registry that his name has to be deleted from the list of AORs. Then the advocate needs to complete 1 year training under an AOR approved by the court. That is, under an AOR who is already under an advocate who is already an AOR. Then after the completion of that 1 year period, then the advocate has to appear for this, of course, this exam, which comprehensively Mr. Sinha has dealt with. Then another important point is that the AOR has to have an office in Delhi within a radius of 16 kilometers from the court, and also give an undertaking to employ a clerk, which is a registered clerk of the said advocate on record with the Supreme Court within 1 month of the advocate being registered as an AOR. And he has to pay his registration charges. So an advocate on record basically has to have an office. He has to clear the exam. He has to have an office in Delhi within the prescribed radius from the Supreme Court, and he has to have a registered clerk. Now, the benefits and the object of having all this are apparent. You have to be able, The court has to be able to hold you responsible for any misdemeanor or any incorrect statement or any lapses which happen in filing or conducting a matter before the Supreme Court. Now, is it mandatory to engage in AOR for filing an SLP in the Supreme Court? Yes, it is mandatory. Save and except if you want to file the petition in person, then you don't need an AOR. Now, what is the difference between an advocate, a normal advocate, and an AOR? I'm an advocate, Mr. Sinha is an AOR. Does he stop being an advocate? Not at all. He's got an additional qualification. So I, as an advocate, can associate with an advocate on record, file my matters through him, and appear myself or engage a senior counsel. So, because what happens is when I'm, say, for example, I have come from the hinterland of, I don't call it a hinterland now, but I come from a city called Pune. I don't know that I have to be an AOR. I have been practicing my trial. I have been practicing as a trial court lawyer. Now, after practicing in the trial court, I have no understanding. What am I going to do? AOR? Oh my God! Let me engage Sinha. I don't want to give the exam. You can do that. You can do that. You don't have to take the responsibility. You don't have to be, accountable. You don't have to give this exam, but you can still continue with your practice as a lawyer. That also has its own benefits. I don't have to have a registered clerk. I can use Mr. Sinha's registered clerk, as my clerk. All I have to do is to pay his charges, right? So, and I can practice in all the courts in Delhi and outside Delhi, in any court in India. I can practice in the lower courts, file my own wakalat. I can practice in the High Court, file my own wakalat. Except for Supreme Court, I don't have to be an advocate on record anywhere, right? That is nothing. I'm not saying this to undermine the importance of becoming an AOR at all. It is just that I'm telling you that just as a guidance, that in case you are not an AOR, in case you don't successfully complete the examination, or you're not successful in giving the examination, there is nothing to fret, nothing to worry. Your practice will take off even without becoming an AOR. As did mine. And like Sanjay said, I am reasonably well placed. I don't call myself a very brilliant or a very successful lawyer, but I'm okay. I'm doing all right. And the fact that Sanjay has invited me probably speaks a little for that also.
We all know it. And so grateful for taking out.
That's your kindness, Mrs. That's really your kindness.
And the best part is, in your whatever you are saying, still you are saying. I mean, I'm not interrupting, but I'm really very happy that what a great clarity you have given. Wonderful. Please continue. Thank you very much.
So the whole idea is to become a lawyer, to be a lawyer. And my only advice to you as students and as aspiring lawyers is this: understand that you hold your talent in trust for those clients and for those persons who need it. It has to be a gratifying task. It doesn't matter, whether you are arguing the matter or you are giving advice, or you are simply drafting a matter and filing it and appearing along with it. What matters is how much practical relief are you able to give to your client. There are various kinds of practices. You can do a chamber practice, as in you can only be consulting lawyer, or you can practice in the trial court, wonderful. You can practice in the High Court, or you can practice in the Supreme Court. As a young lawyer, actually, you don't have the opportunity, or you don't have the luxury of choosing your specialization. Nowadays, I see when juniors are working under me, I see that most of the juniors, coming from law universities, they are excellent, as far as the academics is concerned. They have so much exposure, much more than we ever had before. I'm sure Mr. Sinha would agree with me. But the point is that what they come with in mind is this, that I'm going to do this, I'm going to specialize in this, I'm going to specialize in that, and no more. But it is the clients who come to you who actually choose your specialization. For somebody who doesn't have like me, I'm a first generation lawyer. If a lady comes to me and asks me that, Madam, I want to consult you in respect of a family matter, can I tell her that, no, bhai, I'm going to only specialize in criminal law, or I'm going to specialize in constitutional law, and I cannot advise you? No, what you have to do is this. You have to understand her matter. You have to talk to her, understand it. No matter that you don't know what you're going to advise her yet. That's the crucial difference between a doctor and a lawyer. You see, for a doctor, if a patient comes to you, or you're going to open up somebody's body for surgery, you can't look over there and say, oh my God, let me go and consult a book and come back and do it. But as a lawyer, you can do that. That's the best part of being a lawyer. You can say, okay, you've given your instructions, you've given your problem. Please give me all these papers. I will read those papers and revert. You can then go back to the law books. You can then, if you have a senior, consult a senior. Think for yourself. Think out of the box. How is and what is the best way in which I can actually give practical relief to this woman? She may come to you and say, Madam Lawyer, I want to file a divorce petition against my husband. But she may not be wanting a divorce. All she may be wanting is security of maintenance, of looking after herself and her children, and ensuring that her husband doesn't trouble her, or some discord. You can counsel, you can do counsel, you can ask her, is it really what you want? Because all she knows is divorce petition file करोगे तो maintenance नहीं मिलेगा, अगर 5 साल के ऊपर बेटी है तो custody नहीं मिलेगा. All these, like Mr. Sinha said, WhatsApp institutions, or your friends telling you, or some anybody, of your relatives telling you from their own experiences, or from advice which they may have got from their friends who are not really legal persons. So you have to actually guide them properly and ensure that they are on the right path in the pursuit of justice. What matters is not judging. What matters is justice. You are not sitting in your armchair in your office in a conference to judge a client. He's come to you obviously because he's in trouble, because he has done something wrong in his life, or he may not have done something. Life has done some wrong to him, as I may very well put it. But the whole point is to do justice, to ensure that in some way or the other, whichever law may apply to the facts of that particular case, and seek a proper path in which that person and your client gets justice. So whether you are an AOR or not an AOR, whether you are an arguing lawyer, whether you are a Supreme Court lawyer or a trial court lawyer, principal object of being a lawyer, one, of course, is to do work for the benefit of your client. Two, of course, to earn money. That's your profession. You need to earn. गाय अगर घास से दोस्ती करेगी तो खाएगी क्या? Obviously. So you have to earn, you have to see your own career also. 3, excel yourself, upgrade yourself, read. See, these live law and bar and bench, these apps which have come up are really, really good. We used to not have those in our times. We had to go back to the Supreme Court Digest and keep reading case laws and, subscribe to this and subscribe. And we used to get those books, which were very, very enlightening and fulfilling in their own manner. But today, what judgment Supreme Court has passed today. So this is the top grade law, the view of the Supreme Court as on date, as at the moment when you're reading it, right? So you're on top of it. You are abreast of the world, abreast with the world, at least with the legal world. So all these things are very important in your practice as a lawyer. Now, just the last end, I will just address the women lawyers over here, the women law students over here. We're going to celebrate the International Women's Day on 8th of March. We may have broken the glass ceilings. There are a lot of women lawyers, now we have women judges, and like he said, Justice Indu Malhotra, you have 5 of them in the Supreme Court right now. But for us women lawyers, the struggle is much more harder than what it is for men lawyers. A criminal, when I just graduated and I wanted to join a very famous criminal lawyer in Maharashtra, he told me, Neela, main to sikha lunga tumhe, but where will you get the clients? A person who is against whom some trial is going on for murder doesn't have that mindset to trust a woman lawyer unless you have some family background. Unless it's Mr. Jethlani's daughter or daughter-in-law or somebody else. Nobody's going to come to Neela Gokhale. Kaun hai Neela Gokhale? It's my liberty which is going to be, it's at stake. I don't want to die. I don't want to be convicted. So they will go to obviously a man lawyer who doesn't have to prove himself. And whereas we as women, we do have to prove ourselves over and over again. So that is, kitna bhi aap bolo ki yes, we are on the, we have broken the glass ceiling. Yes, we have. We have done it all. And we are capable of doing much, much more. But the struggle, it's not an ideal world, it's not an ideal society. We have a struggle wherein we have to still prove ourselves over and again. Do not fret. My advice to you is do not fret, do not give up. There are a lot of good people in the world, lot of good people in the legal circles who are going to hold your hand and take you along with them. So do not go, do not feel unconfident or, underconfident on this aspect at all. Just do your job, ensure that you don't do anything wrong. Don't choose the wrong path. Better to have a deferred gratification than you get something right now, right here. Money is going to follow you. Do the work, money will come after you. Don't just do it for money. Today, if you do social work, I started by consulting with women in Mahila Sevagram. Now, today I have a PhD in that subject. I never thought that I'm going to have a doctorate in that subject. I did the grassroots level work, just thinking that I'm just doing practice, filing adoption matters in the family court of Pune. I never thought that I would be one day, a member in the Kara committees, or in the VCA, the voluntary coordinating agency committees, which I did experience later in the later part of my career. All right. So this is what it is. Choose your path carefully, but once you choose it, don't stop. Just go on, and there's always a vacancy at the top. Just remember that. And all of us need not be at the top. It is what we do, what relief we give our clients ultimately is what matters. All right. So I think I would just like to end my short lecture here and not take up your time further. Sanjay ji, over to you.
So grateful to you, Neela ji. And I must say, there are hundreds of students there on YouTube who are listening to you right now. And after this session, this session will be permanently there on YouTube. People will take lot inspiration, especially the lady lawyers will certainly take. And we really celebrate you. We really know that the way you have done and the progress which you have done, it's remarkable. So you are an inspiration to others. Thank you very much for taking out time, and it was indeed very lucid, very smooth, and very practical things which you discussed. I'm so kind of you that you have taken out time. Thank you very much. And now I go to my team. There are many things which were there initially, DK, in my mind, and when I interrupted in between, and you both have really answered all of them. Everything, all the clarity I think my students must have got by now. Thank you very much once again to you. Arpita, you are there, and we have got Jyoti Prakash. Yes, still we have not finished. Yeah, because you want to say something.
Just an element of clarification. Firstly, Neela and Sanjay both are themselves an excellent practitioners of the Supreme Court. But small mini correction is there. Instead of Article 141, it was 145, in which the Supreme Court has powers under the Constitution of India.
All right. Yeah.
And I forgot to clarify that aspect, which Neela has pointed out. For that, one has to see Section 30 of the Advocates Act. In fact, the entire chapter pertains to the advocate's right to practice. Chapter 4 under the Advocates Act. Now this says, subject to the provisions of this act, that is the Advocates Act, every advocate whose name is entered in the state roll shall be entitled as of right to practice throughout the territories to which this act extends. First, in all courts, including the Supreme Court. So the legislature has expressly used the word Supreme Court. So therefore, as a matter of right, you can practice at the Supreme Court under the Advocates Act. Now, that was a short. Over to you.
Yes, Arpita. Yes, I think, thank you very much for that clarification, and what Advocates Act says, you have clarified that. And overall, I think in this 1 hour plus package, which we have, the two eminent personalities of Supreme Court have really enlightened us. If there is any question, Arpita, Ananya, please check it. Otherwise, I will invite my dear Ananya. Is there something you want to ask? I don't
No,
think
sir, there's no question, but I would like to thanks both the guests for today's event, because I personally feel as a law student, someone pursuing law, a lot of doubts come in our mind when we consult regarding like what career we need to choose, like where we need to go. And here, Neela ma'am and Sinha sir have really, guide us through a lot of things. As Neela ma'am said that other than AOR, there are a lot of things that a lawyer can do, a budding lawyer can choose from. So I'm really thankful for your guidance. Thank you.
Arpita, that is why, these small capsules or webinars which we do, and in such a short notice, these eminent personalities like Neela ji, DK Saab, they have taken out time for us. And we are really grateful to both of them. This platform we have created for this only. Our objective is to guide, mentor, to speak to the people who are going to be our next generation. You are going to take place of Neela ji. You are going to take place of DK ji. My place. All of you are going to come there, and for that purpose only, so that we show you the right path. With today's discussion, I think many of and I'm being very straightforward here and say that even today with this session I have learned so many things. Thank you very much. And now I request Jyoti Prakash. He has joined us. He is being a great instrumental against all the in all the BSK Legals webinar and events. Jyoti Prakash Datta. He has joined us from Bhubaneswar. Welcome. And he himself is a lawyer. He was a student. From then he is with us. Thank you, Jyoti.
Thank you, sir. Thank you for your appreciation. It means a lot, sir. And I don't think anything is left for which I should say anything. But I will definitely thank Mr. D.K. Sinha and Neela Gokhale for enlightening us about the procedures that are involved in the examination of advocates and record. Sir has very beautifully explained as to how we should go about the cases. The important cases are very much important for advocates and record examination. He has said that we have to read the head notes only as a backup, because head notes are only the summary of the cases, but we have to go through the judgment in detail so as to get a detailed knowledge about the judgment and to appear in the examination in a proper manner. What is more beautiful about his lecture was he explained all these things with his experiences. He has given so many memories and anecdotes. I think that is very much important here. And except that, Neela ma'am has also explained from another perspective, like if we don't choose to be an advocate on record, what we can do. So that was really enlightening, ma'am. Thank you, sir, and thank you, ma'am. And thank you, Sanjay, sir, for organizing this event. It is really a very important event, and it is going to be stored in the YouTube so that many people will, in the future, will get to know about the advocate on record examination, and it will definitely help them to prepare well. Thank you, sir. Thank you, ma'am.
Neela ji and DK Saab, just wanted to inform you there is over 1,000 footfall in our YouTube today in this program. So over 1,000 students have already watched us and they are watching us. So this is, I think, with our short, this is what I tell my students, that whatever, and that's what Neela ji said, whatever small contribution you can do, please contribute. So that's what was the spirit behind this program. Once again, from the core of my heart, I want to thank you, Dr. Neela, and of course, DK Sinha ji. So grateful to both of you. And thank you very much, the team which is behind this. I don't do anything. I mean, these people, this is the event organized by students. Thank you very much.